look at what are the violations of NAFTA provision that Metalclad had claimed and how is it decided, and then we will also discuss little bit about the my concluding remarks on this particular case, Metalclad versus Mexico. So, as discussed in the earlier video about the factual circumstances, I hope you are clear with regard to the factual circumstances. So, Metalclad basically challenged two measures. One was the denial of construction permit and the second was the ecological decree. And the violation that they had claimed was with regard to Article 1105 of Chapter 11 of NAFTA, which is fair and equitable treatment, and also Metalclad claimed the violation of Article 1110 provision of NAFTA, which was expropriation provision. How did the tribunal look at these particular claims? Firstly, with regard to Article 1105, tribunal was presented with two contrasting arguments. Metalclad stated that it is only the federal government that had the authority to regulate hazardous waste. So, therefore, any regulatory measures or anything that has to be taken, it can only be done so by the federal government. This was Metalclad's argument. But on the other hand, Mexico was stating that even the state government as well as a municipality have the authority to regulate hazardous waste and landfill. So, there were two contrary interpretations of who has the authority to regulate hazardous waste. Then the tribunal looked at the Mexican law and the tribunal came to the conclusion that it was a federal government that had the authority to regulate hazardous waste and the municipality can only issue the construction permit. It did not have any other authority to look at the environmental impact. So, this is what the tribunal had concluded. One interesting thing that I see here is it's Mexico who had enacted the law. So, basically the interpretation of the enacting authority was not per se or prima facie relied on by the tribunal, but rather it undertook an analysis and it interpreted the Mexican laws in order to arrive at the conclusion who had the authorities, and then it finally stated that it's a federal government that had the authority. And the fact that there was no legal certainty and there was also Metalclad tribunal stated there was also violation of transparency provision of NAFTA, which is Article 102. And why did it arrive at this particular conclusion? Because Metalclad tribunal noted that initially federal officials had granted the permits, and when the municipality asked Metalclad to cease the building operation, then another statement comes from the federal officials stating that that will be granted and it is a mere formality and all of that, and then additional permits is given. So, therefore, Metalclad tribunal stated that Mexico failed to give a transparent and predictable environment for Metalclad's investment, and this is something that violates the transparency provision of NAFTA, Article 102, and therefore, there is a violation of 1105 of NAFTA as well, Article 1105. So, if you remember this particular provision in Metalclad case, what was held was there is a violation of Article 102 and that resulted in violation of Article 1105 as well. As we will discuss in the future, we will discuss this in the future, that this particular approach of the tribunal wherein a violation of one provision of a treaty results in violation of fair and equitable clause is something that will come under scrutiny. This Metalclad case was decided in 2000. Subsequently, another case was filed under NAFTA against the United States, Methanex versus United States. We will discuss this case also in detail. When this case was pending, then the FTC, Free Trade Commission of NAFTA, came out with an interpretation saying that a violation of another provision of NAFTA will not be considered as violation of Article 1105. So, basically how Metalclad Tribunal had approached this particular interpretation of Article 1105 will be addressed by FTC by issuing an interpretation of NAFTA itself, NAFTA Article 1105 provision, right. So, please note, but this is how the Metalclad Tribunal had decided this particular issue. Violation of transparency leads to violation of Article 1105. and said there was no certainty, there was no predictability, predictable framework given to Metalclad investment, and all of that was stated by Metalclad Tribunal. With regard to the second issue of expropriation, we could see that Metalclad Tribunal again ruled in favor of Metalclad. Why? Because Metalclad Tribunal stated that when the municipality decided to not deny the construction permit, it did not give any opportunity of being heard to Metalclad. Metalclad was not even aware of the meeting wherein they decided to deny the application for construction permit. So, and also here the interesting thing here is the Metalclad Tribunal stated that there is the denial of construction permits is tantamount to it amounts to expropriation, and then it goes on to add one more line. It need not make a finding of expropriation based on ecological decree that was enacted by the government. Please note, this is the most interesting part of the Metalclad award, and that's something that's very relevant for our course, International Investment Law and the Environment. So, there is an environmental decree, right, ecological decree, which protects the indigenous endemic cacti species. Now, what is the tribunal saying in reference to that ecological decree? The tribunal was saying that it need not make a finding on expropriation based on ecological decree, and it goes and further it makes a statement, the ecological decree in and of itself amounts to expropriation. Right. So, this dicta of Metalclad Tribunal is something that I am personally bothered with. If if that is not something relevant for the tribunal to make a finding of expropriation, why does it just out of the blue state that the ecological decree itself would be considered as expropriation? Now, the interesting fact here is, with regard to the ecological decree, it had made certain observations. And one of the observation is with regard to Article 1114. If you look at Article 1114 of NAFTA, it clearly stipulates that investment activity should not be carried out in a manner that is against environmental concerns, right. So, that sort of a thing is mentioned already in NAFTA Article 1114. So, here tribunal went ahead and stated that it need not consider Article 1114 because the very fact that federal permits were granted to Metalclad shows that Metalclad was already undertaking the project in aligning with environmental concerns, environmental issues and all of that. So, that is how the tribunal made a remark with regard to whether it will look at Article 1114 or not. And interestingly, it also made one more statement that there were many scientific evidence submitted by Metalclad in Mexico with regard to the suitability of that particular site, and then here we could see that Metalclad Tribunal stated that it need not look at the suitability of the landfill, it need not look at the scientific evidence, right. So, and it did not provide any justification as to why it does not want to look at the scientific evidence. Now, on the issue of expropriation, Metalclad Tribunal stated one line saying that state officials and the municipality had not adduced any evidence with regard to the unsuitability of the site for landfill. Now, here Metalclad had only referred to one decision in the award. Metalclad Tribunal had referred to only one study in the award, that was the study conducted by the Autonomous University of SLP. If we look at Mexico's submission, respondent submission, we see there were other studies also that were referred to. One of them was where the state director of the environment was a professor at that university, but eventually he became a state director for the environment, but he also came to the conclusion that the site was suitable. But there was other study that was conducted by again certain professors who stated that the site was not suitable. Metalclad sort of questioned the validity of the second study, which stated that it is not suitable because one of the professors eventually take up a post with the state owned hazardous waste management facility. So, on that ground Metalclad was contesting it. Now what I want to draw your attention to is the fact that Metalclad Tribunal only referred to one study by one university that was favorable to Metalclad. So, what I feel here is I am not convinced by the dicta that Metalclad had stated with regard to the ecological degree in and of itself would constitute expropriation, because it did not conduct an analysis. If Metalclad Tribunal did not look at Article 1114, it did not, it explicitly stated that it will not look at scientific evidence, and for this particular reason many environmentalists also criticize Metalclad award by saying that it puts investor interest on a higher pedestal compared to environmental concern. But the matter was further complicated. Many other organizations and associations criticized the Metalclad award, and some of the parts of this Metalclad award was even struck down by British Columbia court also. So, since the seat of the arbitration was Vancouver, so here a case was filed to review this particular award before the British Columbia court, and they did not also find there was certain parts of the award was struck down by British Columbia award. And the next complication that had come in the context of this particular case was, apparently as per secondary literature, there was some fight between the Mexican federal government and the state government with regard to who will pay the compensation amount to Metalclad as well. And we can also see one other secondary literature making a mention that Metalclad CEO himself had stated that they regret going to investment arbitration. So, for many reasons, since it was like I said, Metalclad case had gotten significance because it is criticized at the international level for whatever reasons, and the internal fight between federal government and the state government, Metalclad CEO regretting filing an investment arbitration sort of tells us the complexities of the interaction between environment and international investment law. So, that probably the significance of this course also stems from the problems that were exposed by Metalclad versus Mexico. So, with this we will conclude our discussion on Metalclad versus Mexico, and in the next lecture we will discuss one other case, and that where an environmental measure was involved in an investment dispute. Thank you.